Okay, we'll get started. Thank you very much for coming. I know it's a tough night. We've got some competition with baseball and debates and other things, but this is going to be more interesting, I can tell you. I'm Bruce Stillman. I'm president of the laboratory, and since many of you don't often come to Cold Spring Harbor, some of you do, but some of you, I see a lot of new faces here. I'll just tell you a little bit about the laboratory because some of it has relevance to this evening's lecture. We're 125 years old this year. We're a medical research and biological research institution and also a science educational institution. And we were chartered in 1890 as an educational institution, a spin-out of the Brooklyn Institute of Arts and Sciences, but then very quickly became an independent organization that was the first institution to do genetics in the United States, focus on genetics, and that was back in 1902, just after Mendel's laws of genetics were rediscovered. The current laboratory has 6 divisions of the laboratory. The largest is the research division, which focuses on research in cancer, neuroscience, plant science, and quantitative biology. But we also have a lot of educational divisions. We have a graduate school, so we're a degree-granting institution. We have the Cold Spring Harbor Press that publishes books and journals and other things for science. This auditorium is the center of a conference center that we run, so we have a large conference center that has about 30 meetings a year at Cold Spring Harbor, bringing about 8,000 of the world's scientists to Cold Spring Harbor to attend scientific conferences. And we also teach courses to scientists, these are practicing scientists, to teach them the latest technologies in science. We also have the world's largest school education program in science called the DNA Learning Center. There's a school in Cold Spring Harbor that we own. And just on Long Island alone, we teach 38,000 students a year in laboratory-based science classes to demonstrate genetics and molecular biology and other areas of life sciences to those students. But we have helped start learning centers across the country. The last one we opened is in collaboration with Notre Dame University. I still haven't got tickets to the football game yet. But we've also opened learning centers in Europe, in Australia, in Singapore, and we're now building one of the largest ones in China. And so this is a very, very broad program that starts at middle school and goes all the way up to seniors at high school. And the final program I wanted to mention, which is relevant to tonight's lecture, is Banbury Center, which is in Lloyd Harbor, across the other side of the harbor. It's a 54-acre estate that was given to the laboratory in 1976 that came with an endowment to maintain the estate, and it's in a beautiful estate which we maintain in its original condition. And there we converted the 6-car garages into a small conference center where we focus on bringing people together who have normally not met each other that are related to the life, medical, and agricultural sciences. And we bring politicians and scientists, we bring lawyers, as you'll hear, and scientists together to deal with policy issues, but also bringing scientists together with clinicians to advance certain areas of clinical research. And this center has been enormously influential, and you'll hear about one of the things that sprung out of a meeting there at the Banbury Center from Peter. This lecture series has actually 2 purposes tonight. One is that we have a series of, many of you know, a series of lectures throughout this year and next year to celebrate our 125th anniversary. It's called the 125th Anniversary Lecture Series. And this lecture is also part of an annual lecture that is for the Lorraine Grace Ethics Lecture, and this is Lorraine Grace, Oliver and Lorraine Grace Auditorium, which we're in. And unfortunately, Lorraine died this year, but at a very significant age, I should say. And but the Lorraine Grace Ethics Lecture is a series of lectures that's been held since 2009 on the relationship between science and society. And of course, Peter and I were just talking, and there are lots and lots of issues in the United States and elsewhere that deal with the issues between science and society, including lectures we've had from Richard Leakey, who talked about human behavior, which was very interesting. This evening's lecture is from Peter Neufeld, who I think many of you should know him and what he and Barry Scheck have done. He is a lawyer who is a partner in his law firm with Barry, but also started the Innocence Project, and that's done through the Benjamin Cardozo School of Law. And that project has been extraordinarily influential and has not only influenced the issue about people who are wrongly convicted and put on death row, but as I hope you'll hear from Peter, has completely, and I mean completely, caused a complete rethink of all forensic science in the United States. And that is something which I think really traces to that project. It turns out that there's very, very little scientific evidence that's been put into forensic science going back well over 100 years. And Peter and Barry had an enormous impact on that, and he'll probably talk about that. I'm a member of the National Academy of Sciences, and the National Academy actually put out a report saying how bad forensic science is in the United States and how many things that the law actually gets wrong. And I think, so as a consequence, Peter was appointed to the National Commission on Forensic Science, which is, he'll probably tell you, is going through and looking at this entire field. So it is a great pleasure this evening to introduce Peter, and I hope we'll hear a fantastic lecture about science and law.
I don't know if this is on. Hi, folks. You could turn down a little bit. I think most people could probably even hear me without it. You know, at first I wondered that, I thought we were actually conflicting with the debate and the baseball game, and then I said, wow, this would be a great group for an experimental psychology study. You know, but you're all outliers, so I don't know what good it would do. I first got involved with Cold Spring Harbor almost 30 years ago now. Jan Witkowski, who I don't think he's here, but Jan was the director of the Banbury Center at Cold Spring Harbor Labs. And they had this idea, and it's really quite something, is they didn't look at genetics simply as a means of doing laboratory research. They were very, very conscious of the fact that genetics, when applied, whether it's in medicine or other applied disciplines, would have an impact, would have a psychological impact, a social impact, a legal impact, would actually transform many aspects of our society. And just as Cold Spring Harbor Labs was very much involved with the Human Genome Project and studying the social, legal, and ethical implications of that, they had this idea in the late 1980s when people in England were first considering DNA testing as something that you might be able to use in a criminal proceeding. In fact, it was initially used in an immigration proceeding in England, not a criminal justice matter. And they had this idea, why don't we bring some folks together who could think about what it would mean if genetics testing was applied to the criminal justice system. What would be the legal ramifications? What would be the social ramifications? And frankly, even in terms of the science. You know, what we do here in this laboratory, they would say, is working with pristine samples, right? And doing disease studies. What happens if you want to use that same technology with a dirty blood stain found on a street? Okay, does it change any of the parameters, the controls? How reliable will it be? What kind of studies do we have to do to validate the methods that we're going to use to do that? Well, no one had thought about that before. They just went sort of blithely ahead and started doing it in the late 80s. But the folks here said, well, let's put the brakes on, let's give it some serious thought. And out of the meeting that was held here in the late 80s, which I participated in, and Jan ran, a lot of interesting people got together. And as a result of that meeting, the National Academy of Science then had two major study groups in the early 90s think about creating standards for forensic DNA testing in America. And it really became the sort of first major effort to come up with a reliable standard-setting mechanism for the introduction of DNA testing in the criminal justice system. So a lot of that credit goes to this laboratory and the work that they were doing. And I think you folks are still thinking about what are the implications of our research all the time. And that's a great thing, and we should all be part of that. But I'm going to talk about one aspect of the implications of their research, and that is the implications on the criminal justice system. And perhaps the best way to start is to take you back to Georgetown, Washington, D.C., the summer of 1981. A young woman named Catherine Schilling, who was a student at Georgetown University, was spending the summer working for a law firm in the Watergate office building, a building you all know for other reasons. And she worked there as a summer intern. And on the evening of June 21st, she left the Watergate office building, and she was going to walk a few hundred yards into Rock Creek Park, which is a narrow strip of land that separates D.C. proper from Georgetown. Has a little creek running through it. It's a parkland run by the national parks. And she left work, and she was going to cut across the park to head over a little footbridge and go home to her apartment in Georgetown. Well, that night, Ms. Schilling didn't make it. And the next morning, search parties from the law firm and the police went out to look for her, and they found her naked body on the banks of Rock Creek, about 300 yards from the office building. She had been brutally raped, and she'd been shot 4 times in the head. Now, this is the kind of case that those of us who work in the criminal justice system call a heater. So you had the chancellor of Georgetown University calling the head of the police department in D.C. saying, you better solve this thing and solve it quickly. You had people from the law firm, an important law firm, a prestigious law firm, calling the mayor and calling the police chief and saying, you better solve this crime. Now, ordinarily, just from what you know from television and TV dramas involving police, a young woman dies, the usual suspects are the boyfriend or the husband. Well, there was no boyfriend here, and there was no husband here, and so the police didn't have a lead. And one of the things that police do naturally when they don't have a lead is they say, well, have there been similar crimes in this same geographical area, to wit the park, recently? Maybe somebody else we can take a look at. And when they did that, they saw, well, that about 3 weeks earlier, that another woman, but in broad daylight, in front of dozens of people, who was walking home, was accosted by a man who was drunk, by a man named Donald Gates. He was drunk, he was sort of stumbling through the area, and he grabbed a woman's tote bag. They struggled over it, they fell to the ground, and Mr. Gates was arrested for that assault. He was held immediately by passers-by. The police came and took him away and processed him for that, and then he was released on bail. But his name was there in the records. And so the police thought maybe Gates had something to do with this, but they didn't have much. Well, several days after the murder, an informant known as the Bear stumbled himself into police headquarters and said he had information that could break the Schilling murder. Of course, he had an outstanding felony himself for stealing $400 from the Washington, D.C. Police Department, and that he hoped that in exchange for the information he could provide them on the Schilling murder, that they would dismiss the charges against him. And a deal was made. Evidently, he claimed in that statement he gave to the police that he had been in a park at Washington Circle, a series of circles moving through Washington, D.C., where the different avenues intersect. One of them is called Washington Circle. And that a few days earlier, he'd been in that circle with a bunch of other guys who were drinking cheap wine, where he met Donald Gates, who used to show up at this location regularly. And Gates was bragging about how he'd been in Rock Creek Park a few days earlier, that he had met some white woman, that he intended to rob her, but when he tried to rob her, she resisted, and that it morphed into a rape, and that once he raped her, he realized he couldn't leave her that way because he would be caught, and so he took out a gun and shot her and killed her. Well, this was a pretty sketchy story the police were getting from a pretty sketchy guy. And it wasn't enough to arrest Mr. Gates on. They wanted other evidence that would corroborate this informant. And about 2 months later, they got that evidence. Their prayers were answered when they got a call from the FBI crime laboratory. Now, what you have to appreciate, even back in 1981, before the advent of DNA testing, when a person is murdered, particularly a woman who's found naked like that, when they conduct the autopsy, they also collect a rape kit. And they're collecting fluids from her genitals or anything else that's on the surface of the body that might provide leads to the real perpetrator. And in this particular instance, they did collect seminal fluid from her that was running down her thighs, and they collected 2 pubic hairs from her body. She was a young white woman. The 2 pubic hairs appeared to be of what they would call in those days Negroid origin. Those hairs and that semen was sent to the FBI laboratory. Now, in those days, before they had DNA, it wasn't that unusual that when you did serology testing, looking for ABO blood groups, that you wouldn't get a result. Or if you did get a result, it wouldn't be very meaningful because so many people within the population either were type A or type O or type B or type AB. Those were the 4 types, not very polymorphic. And in this instance, the serology evidence was totally uninformative. And so they sent the hairs to the FBI's hair unit. And the hair unit was part of the trace unit, which did hairs and fibers. And it had 15 full-time hair and fiber analysts in it. And it was given to an FBI agent, hair examiner named Michael Malone. And he took those 2 pubic hairs. And of course, Mr. Gates was picked up. And Mr. Gates was required to give samples of his own pubic hair and his own head hair, which he did. And 2 months after this informant had walked into the police headquarters, they get a call from the FBI. It's a match. Now, what do they mean by a match? What they meant was that these people who had been doing hair microscopy look at the hairs under a microscope, look at the hairs from the suspect under a microscope, look at approximately 24 class characteristics, color of hair, width of hairs, did they have certain bodies, are those bodies that we all have, are they thin, fat, things like that, okay? Things that you would see better under the microscope. For none of these characteristics is anybody unique or even very rare, but by looking at 20 characteristics over a range of someone's hair, you can say that they're similar. That's all you could say, that a defendant and the crime scene hairs was similar. They didn't have databases like they had for DNA where you could determine what percentage of the population would have a particular genetic profile and then come up with numbers of 1 in a billion or 1 in a million, nothing like that. They just had the ability to say that 2 things were similar. But by the time the case went to trial in the fall of 1982, the FBI agent didn't simply testify that the hairs were similar. Instead, he said, okay, that they were microscopically indistinguishable, that the chances that the hairs came from anyone other than Mr. Gates were extraordinarily small, and that he had looked at hairs in 10,000 cases in his career, and that when he compared a suspect's hair to a victim's hair, he was only unable to distinguish those hairs on 2 instances out of 10,000 occasions. And so this evidence now was extremely powerful. And so you had the powerful hair evidence on the one hand and the snitch on the other hand saying he had this conversation with Donald Gates where Donald Gates had confessed to him to committing this murder. Mr. Gates was a black man who had recently been discharged from the Army. He was having a difficult time reacclimatizing to civilian life. He worked for an employment agency that got day work for people from time to time. He had a bit of a drinking problem, didn't have a regular lifestyle where there would be many people who could account for his time. He was convicted, and he was sentenced to life in prison. A very serious crime. It warranted a very serious sentence. Gates went to prison in 1982, to some of the worst prisons in the country, in fact, where there were serious riots, a lot of stabbings, shootings, a lot of people he saw get killed, beaten, tortured at times. But in any event, in 1988, about the same time that the meeting was held here at the Banbury Center, and a few articles appeared in the newspapers about this new thing called DNA testing, Donald Gates became one of the first people in America to write to a judge and say, I want DNA testing done on those hairs and on that semen that was collected because I didn't commit this crime, and that testing will set me free. And the judge ordered testing. And he ordered testing in 1988, but at that point in time, even forensic DNA testing was in its infancy, and you needed a lot of biological material to get a result. Okay? Ideally, what you want in any kind of forensic assay is you want a test that will give you results from a very minute specimen, and also a test that's very discriminating, very specific. So it rules out all the false positives. That's what you want. DNA was better than serology, but not nearly as powerful as it is today. So when they did the testing in 1988, the tests were inconclusive and didn't help Mr. Gates, and so he continued to serve his life sentence in prison. In 2009, he petitioned the court again, saying that the technology was much improved and that he deserved a second chance. He got the second chance. The hairs no longer existed, but the semen did, and it was well preserved. They did DNA testing, using state-of-the-art DNA testing a few years ago, and he was completely cleared. He wasn't the source of the semen. Eventually, that profile from the semen was run through a national convicted offender data bank, which came into existence in 1994 and has been growing by leaps and bounds ever since. And they got a hit. They got a hit to a guy who had been working as a part-time janitor, filling in that night, the night Ms. Schilling went absent, at that law firm. He was the source. And subsequently, he had gone on to assault other women. He had stabbed another woman. He had gone to prison, and he died while serving that sentence. So Mr. Gates was exonerated in 2009. Everybody agreed he was completely innocent. He had nothing to do with this crime. It was committed by this other man. Mr. Gates became one of the 330 people who have now been exonerated through post-conviction DNA testing in this country. Who are those 330 people? Well, on average, they served about 14 years in prison. And in about half the cases, we've not only exonerated somebody, but we've managed to identify the real perpetrator of the crime. We believe that the numbers that we have are the tip of the iceberg, that proverbial iceberg. In fact, there have been 1,600 exonerated during the same time frame through non-DNA testing in this country. And the causes of all those wrongful convictions are the same as the causes we see in the 330 DNA exonerations. And it makes sense. If you have an informant, an unreliable snitch, in Mr. Gates's case, you could have an unreliable snitch in thousands of other cases where there's simply no biology to test and corroborate that snitch or refute that snitch. You can have an eyewitness in a case of a rape where there is biology. You can have an eyewitness in a pocketbook snatch where there is no biology to test. You could have a drive-by shooting where no biology is left on the perpetrator or on the victim. Nevertheless, they could be relying on bringing him in and getting him to confess. And so it became very important to us at the Innocence Project to begin to deconstruct these 330 cases and find out what were the causes. We knew what got them out, DNA, but what got them in? And we knew that we had to answer those questions because if we didn't, we would risk having thousands of more wrongful convictions in the future. So that became a very important policy program of the Innocence Project. And when we began to deconstruct the 330 cases, a lot of the contributing factors to wrongful convictions will not come as a surprise to you. Things like eyewitness identifications, false confessions, police forcing somebody, compelling someone to confess, even though they were completely innocent. You know, you think about this, you say, my God, I would never confess to something I didn't do, but you'd be surprised. A lot of these people were mentally challenged. Some of them had emotional problems. A lot of them were juveniles. And some of them were ordinary people who just by their personality made them very compliant, made them very malleable, made them the kind of people who wanted to please and would confess to something they didn't do just to get out of this horrible interrogation that might go on for hours and hours. Believing, as some of our clients did, that it didn't matter if they falsely confessed because ultimately there would be no physical evidence to connect them to the crime, and so they would be freed. Unfortunately, they were mistaken and they were convicted. So that's what we did, and then we worked with a lot of scientists to come up with remedies to improve all these types of evidence gathering that are done by the police to make them more scientific, more empirically based, more reliable, and hopefully result in having fewer wrongful convictions. Take the Gates case, for instance. You realize very quickly that the two causes were undue reliance on this informant, okay, by the detectives from homicide at the Metropolitan Police Department, and somebody from the elite FBI crime laboratory, considered the finest and largest crime laboratory in the United States of America, offering scientifically invalid testimony on the witness stand, offering testimony where he grossly exaggerated the probative value of the evidence. And that gross exaggeration contributed to this wrongful conviction. And so when we first got the Gates case, resolved, and we looked at that testimony, we were able to point out the exaggeration. And we talked to the FBI about it, but they thought it was a one-off situation. And at that point in time, they were not very interested in doing anything about it. But the next year, we had a second exoneration that was secured by the public defender lawyers in DC, where another FBI agent had testified about a hair match and used basically the same language that the first examiner used in Mr. Gates' case. And then a year after that, there was a third case in DC, where a third agent from the hair unit had basically given the same kind of unscientific testimony, exaggerating the probative value of the hair evidence. Well, now we went back to the FBI and we said, look, this is a systemic problem. It's not about an outlier. We've got to go back, you've got to go back, and you've got to look at all these cases where your examiners looked at hair and then went to court and testified. And we have to determine in how many cases those analysts working for the FBI laboratory made errors, provided scientifically invalid testimony, because you have an ethical obligation as scientists to correct errors that were made. And you have a duty to notify all the people who may have been adversely affected by the errors that emanated from your laboratory. Now, this notion of duty to correct and notify is something that is part of the medical field. It's part of some other professional fields, but it had never been part of the crime laboratory consciousness until this time. And we made that point, and the FBI leadership agreed. And we worked out a collaboration with the FBI and with the National Association of Criminal Defense Lawyers, where the FBI would find all these old cases, and they would have them re-examined internally by a team of their own people, lawyers and scientists. And so far, they've picked up 2,500 cases. We think there are probably at least twice or three times that many, but they haven't been able to find them all yet because they didn't have good record keeping back in the early 80s to do that. And so far, they've examined the transcripts from the first 300 cases. And of the first 300 transcripts they've examined of FBI agent hair examiners, they released the results in the spring of 2015. And the results were quite extraordinary. The results were that in 96% of those cases, their own examiners offered scientifically invalid testimony in trial after trial after trial. In many of those cases, those were death penalty cases. In 14 of those cases, the people had been executed. And it wasn't that it was 1, 2, or 3 examiners who were offering invalid testimony. It was 24 out of the 26 people who worked in that unit over a 20-year period. And so how did something like this happen? You know, where did it come from? What are the consequences of something like this? Well, obviously, this became the largest scandal in the FBI laboratory's history. It was quickly identified that it wasn't limited to the FBI laboratory, because one of the things that happened in the United States is that when other local and state laboratories were developed in the 1980s and 1990s, they would send their people to be trained at the FBI. And so the FBI offered a 2-week course in hair microscopy to train state and local analysts from all over America, hundreds of them. And it became very clear through depositions that were taken and notes that were preserved that the FBI were teaching the state and local analysts to testify in the same scientifically invalid way that they had been testifying. And so what started out as a review of these thousands of FBI cases is now transitioning into a review of state analyst cases as well. Texas is doing a review, North Carolina is doing a review, New York is just commencing a review, and pretty soon we expect, since the Justice Department has been recommending to states that they do reviews, that accrediting bodies are recommending that states do these reviews, that pretty soon we expect at least half the states to pick it up and start doing retrospective reanalysis of thousands and thousands of cases. So that's pretty bad. And the logical question for all of us is, well, what went wrong? Is it just hair? No, it's not just hair, because what we're now seeing and what we're asking the FBI to look at and other labs to look at is whether in other forensic disciplines, okay, involving trace evidence, could be fibers, involving pattern evidence or impression evidence, which includes fingerprints, ballistics, tire marks, shoe prints, bite marks, you name it. All those other disciplines that have been routinely used by law enforcement all over America, where there are no databases like DNA, examiners were making statements that violated certain fundamental principles of statistics and mathematics and probabilities. They didn't care, they didn't know. It didn't matter. And so, you know, this is a big deal. And the domino effect, if you will, of what we uncovered here will have extraordinary consequences, not just for hair, but for many other disciplines, not just in the United States, but in many other countries. So it's an international problem that has to be dealt with. But how did this go wrong in the first place? Because it doesn't make sense. We all know as consumers of medications, okay, of pharmaceutical products, that there are all these regulatory institutions out there that, you may complain about the FDA, but I assure you, at least there's a gatekeeper there who's looking at the devices and drugs produced by pharmaceutical companies and others and looking for data on, on phase 1, phase 2, phase 3 studies, other data that they have, and then making an evaluation about whether or not this particular product or this particular device has been validated, is reliable for use on the American consumer public. You can't make those determinations yourself. Even your physician can't make those determinations. So that's why we have an FDA out there that does that. But whereas in clinical medicine, we not only have an FDA, we also have basic research, okay, being funded by the National Science Foundation, by the National Institutes of Health. We have applied research. We have thousands of peer-reviewed articles that are published. People attempt to replicate or refute them. All of that happens before the FDA has to pass judgment on whether or not a certain drug or device is going to be sprung on the American public. There never, ever was anything comparable for crime labs as we have in clinical labs. Never. And there are a couple of reasons for that. One of the reasons is that a lot of the disciplines that are used by crime labs are only used by crime labs. They never had a medical application, unlike DNA. DNA started in disease diagnostics long before it was used in a courtroom. So you had the basic research, the applied research, the thousands of peer-reviewed articles. All of that was there. But, you know, who else cares about comparing a bite mark, right? It has no medical application. It has no engineering application. It has no civilian application. It only has a law enforcement application. And the same is true with hair microscopy. Frankly, the same is true with fingerprints, and lots of these different impression and pattern forms of evidence. And so a lot of the standards, a lot of the methods were developed by people in law enforcement, for law enforcement. And they were not people who were trained in the scientific method. They were not people who had advanced degrees in various basic science disciplines. They were law enforcement personnel trying to do their best to come up with some new technique that could advance public safety. Not a bad idea, it's a good one. But none of the kinds of protections that we have for clinical applications were present in criminal or forensic applications. It's a different approach. In fact, it was the belief up until the 2009 report that came out of the National Academy of Science that the equivalent of the FDA for crime lab evidence is the courtroom, that the courtroom is the crucible. Think about that. You have a defense lawyer and a prosecutor and a judge who are scientifically illiterate making arguments before 12 citizens who generally are scientifically illiterate. And that's supposed to be the equivalent of the gatekeeping function of the FDA. It's ridiculous. And it's been ridiculous for decades, but no one cared. And one of the reasons that we as a politic didn't care in the United States is, after all, they're all guilty. We care about the drugs because we take them all. So we want as much protection as possible. But we don't care about those people because they're all guilty. Well, that thinking began to change, I think, in some part, because of the work of the Innocence Project and the other members of our Innocence Network. And once people started seeing all these innocent people, it became important. It became important because, my God, they're actually innocent, okay? And you don't want that to happen. But it also became a matter of public safety, because we were able to demonstrate that every time you wrongfully convict somebody, the real bad guy is still out there committing other violent crimes. And so it becomes in everybody's interest to try and improve this system. And that's what we've been trying to do. Now, there are ways that we can fix this. There are ways that we can prevent future Donald Gateses from that happening. One of the things we can do is require, not just with new and novel forensic science, but going back and looking at the existing disciplines, is, have they been validated? Is there a sufficient scientific basis to make the assertions that have been made? One of the things that I find mind-boggling for myself right now is I attend these meetings of this National Commission of Forensic Science that was set up by the US government. And there are some Nobel laureates on the commission, there are some federal judges, there are state Supreme Court judges, and then there are some forensic scientists, leading forensic scientists. And what they don't appreciate is it's not enough to validate the bench science. It's not enough to validate that you're using a microscope, which is a scientific instrument, okay, and that you're looking at certain characteristics, and therefore you can say that two things are similar. You have to have a scientific basis for how you interpret the data. You can't just interpret the data with some personal opinion. You have to have a reliable method, a validated method of interpretation. But since these people had no background in statistics or probabilities, they were incapable of doing that. And to this day, they are resistant to it. They will say things like, it's simply my opinion. One of the great things that happened with DNA early on is there's two parts to a forensic DNA test. There's the bench work, where the analyst actually runs the reagents and then scores the genetic profile of a blood stain found at a crime scene, and then separately determines the genetic profile of the accused at perhaps 13 different genetic markers. All right? But then saying they're similar doesn't mean a whole lot unless you know that the likelihood of two folks having those same identical 13 markers, that marker profile, and having the same alleles for each of those 13 markers is 1 in billions, okay? If not even rarer. But there were population studies that were done to allow the scientists to interpret the match as meaning something so probative as that. Without any study of populations, you don't know whether something is rare or common. Now, intuitively, I could be great at matching of knowing whether someone is a man or a woman. But we intuitively know that, so what? It doesn't mean very much if the suspect was a male and the perpetrator was a male. Not very discriminating at all. And DNA, we have that basis for it. But if an analyst comes in and says, I can match the hairs, or I can match the tire treads, you don't know what they really mean by that. You don't know if they're looking at certain basic class characteristics which are very common, or whether they're looking at certain unique characteristics which make the evidence very probative. And so what we are all about now is trying to bring that kind of robust scientific approach that we have in forensic DNA testing to all these other forensic disciplines. And not just to the forensic disciplines. Because the people who believe that they can run a certain kind of lineup or a photo spread and have a witness make an identification believe there's a scientific basis for the legitimacy of that. And they don't realize that if you're working the rape investigation or the murder investigation and you have a witness and you show them 7 photographs and you think only one is the suspect, the others are all fillers, that you may unwittingly say something because of your own cognitive bias to the witness, to the victim, to get them to pick out the person you think is the suspect. And so it makes much more sense scientifically to have the person who runs that identification procedure do it in a double-blind fashion. Another method that is routine, okay, in bench science and DNA and other kinds of disciplines, but has never been considered in criminal justice. Or if you're interrogating a prisoner, videotape it from start to finish. So there'll be a neutral objective record. So you'll know whether or not certain key non-public details about the commission of the crime, did they originate from the suspect? Or were they fed to him even unconsciously by the detective who was very eager to have this person confess? So what we're trying to do is bring all kinds of new methods to crime solving, to investigation, and ultimately to the way that all these cases are adjudicated. We're doing it not only at the Innocence Project, which is of course the largest and the first project that did this. We now have 40 different Innocence projects in the network in this country. There are 18 Innocence projects now abroad that are thinking about this not just as a civil rights issue, but as a human rights issue. And the goal is, the goal is pretty simple. The goal is to transform the criminal justice system So the tools that we use to investigate cases and adjudicate the results will be empirically based, will be much more scientific. And if we can do that, then the outcomes will be more reliable and the entire system will be more just. So let me hear some questions. Okay?